The battle for transparency has just begun. First up, though, is an update for you special from Judicial Watch, who is in the middle of it on the Biden raid on President Trump. Now, Judicial Watch, as soon as the raid happened, as I talked about last week, we leapt into action to try to get access to the information behind the raid, namely the warrant and any supporting information used to justify the raid. And of course, the Biden operation, despite doing something so obviously abusive, so obviously political, so obviously unprecedented, had zero interest in disclosing anything. So we made the court filing. Then the big media came in after us, and they agreed with Judicial Watch, by the way, so we're on the same side as organizations like the New York Times in demanding this transparency. They also demanded that this material be unsealed. Unsealed means the court has granted a motion by the Justice Department to keep the records away from the public. And the court reacted, to its credit, quickly and ordered the Justice Department to respond. And within a few days, after stalling and hemming and hawing, and virtual silence practically from the Justice Department, Attorney General Garland caved and released the warrant, which of course wasn't enough. And you just can't have a little bit of transparency and not a more fulsome disclosure. And so we kept on fighting, and the court obviously already had an order demanding that the Justice Department respond, or giving the Justice Department an opportunity to respond to our request for disclosure. And the Justice Department came in and said, oh, it should all be redacted. And the court said, no, it shouldn't all be redacted. And long story short, he ordered in response to Judicial Watch's request, he ordered the Justice Department to file a partially redacted document. And it was released. It was just released just a few hours before I'm talking to you now. And the document, it's historic because never before has the president's home been raided. And it's very difficult typically to get affidavits like this out in any timely way, but Judicial Watch did it. And obviously the public has an intense interest that outweighs any alleged interest that the Justice Department was pretending to have in keeping this material completely secret. And now we know why they wanted to keep it secret. Because, yes, we were right. There was no good faith basis to raid the president's home. Yes, we were right. They were using the pretext wrongly of the Presidential Records Act and suggesting that the president had classified records on his premises when in fact they were all unclassified, to raid his home. This is weak tea. This affidavit shows that the raid on Trump's home was a raid about nothing. Indeed, the documents show that the Presidential Records Act was the genesis of this raid. When you look at the Presidential Records Act, as I went through carefully with you previously, there is no enforcement mechanism. It's the discretion of the president to decide what's presidential versus what's personal. And by presidential, that means records that are classified. So any record he sees at the White House potentially is classified, and the Presidential Records Act gives him the ability to take that with him and presumptively declassify them automatically as a result. And no one can second guess him in that regard. That's what a court found in a case that Judicial Watch had pursued against Bill Clinton, because we had pursued initially the Justice Department's new legal theory that, hey, Bill Clinton had records after he left the Oval Office. And it looks like they might be presidential records. It looks like they might even be classified presidential records. And the Justice Department came back to us and said, no, you have no right to get these records. And the court agreed. And yet they changed their minds when it came to targeting Trump. And it was obviously pretextual. And everyone who's looked at this affidavit will see, and I encourage you to read it. It's heavily redacted, but there's a lot more here than you might have thought would have been unredacted. So there's some substantial material here. And they're pretending that the records the president he didn't have a right to have. The Presidential Records Act. And they cite someone saw boxes at Mar-a-Lago, as if that's a basis to raid a president's home. And because he voluntarily turned back records that the archives had alleged were presidential records, and I don't think he had to do that or frankly, the archives was right in that regard. And the archives went through the boxes and said, well, some of these records are marked classified. Well, that doesn't matter because they were his. And he had the right to declassify them. And in fact, he did because he had them at his home. That was the theory of law that the Justice Department said if the president had these records after he left, presumptively they're personal. Meaning presumptively they're declassified. And yet they went and they got the judge to approve this warrant. And what's interesting in the affidavit, they acknowledge that there was a dispute. Kash Patel talked about how the records were declassified. There's a lawyer at the end, there's a letter at the end of the document that is written by the president's lawyer asserting his constitutional prerogatives in having these records. So I don't understand why the court, when looking at this material, they see the Justice Department is alleging these records are classified. He sees the president is alleging these records are mine. They are declassified and I have a right to have them. Why it is he would have just said, you know what, there's a dispute here that I'm not going to allow you to raid a president's home until this dispute is resolved in a more clear-cut way. I'm not in a position to judge constitutionally which records are whose, whether they're government records and classified or what President Trump is saying that they're declassified and he has rights under the Presidential Records Act. So I don't think the judge should have signed on to it, but certainly that the Justice Department did a complete 180 and changed their legal position and changed the rules midstream to go after Trump is a wild abuse of power, as I've said. And so I just want to clarify here, though. It is Judicial Watch that got access to this affidavit. And it wasn't disclosed voluntarily by the Justice Department. We had to go to court to force it out. And this is a major victory for transparency. And I encourage you, now that we have the information, to go and review it. And my understanding of the media reaction to this, not that that's the end-all and be-all, is they tend to agree with me here. It's weak tea. There's not much basis here for the outrageous step of raiding a former president's home just a few months before an election. You know what it was about. It was about finding a reason to harass President Trump, try to jail him, and try to prosecute him. And they misused the law, misstated the law, and in my view, improperly got a judge to approve a warrant that had no good faith basis. And I want to talk again about this Clinton case. And it's worth reiterating what a district court judge here in Washington, D.C. found when she looked at information that was kept by Bill Clinton, tapes of conversations he had with foreign leaders and doing other government business. And we had seen initially, hey, they're presidential records, as I've said. And the court came back and said, no, you can't force the archives to do anything about this. And she explained what the law was. And the law is, according to her, and this is Judge Amy Berman Jackson, who's one of the more liberal judges here in the District Court of the District of Columbia. And she did this at the request, by the way, of the archives, that now's done a completely, now's pretending this decision doesn't exist. I want you to listen to this and you think, and ask yourself if you think her analysis would allow this raid to have taken place. Quote from the judge. Under the statutory scheme established by the Presidential Records Act, the decision to segregate personal materials from presidential records is made by the president during the president's term and in his sole discretion. So NARA, the National Archives, could not make a classification decision different from that of the president. Again, since the president is completely entrusted with the management and even the disposal of presidential records, you hear that? Disposal. During his time in office, it would be difficult for this court to conclude that Congress intended that he would have less authority to do what he pleases with what he considers to be his personal records. Again, the Presidential Records Act contains no provision obligating or even permitting the archives to assume control over records that the president categorized and filed separately as personal records. At the conclusion of the president's term, The archivist only assumes responsibility for the presidential records, meaning the ones that they know have been sent over to them as presidential records. Plaintiff, Judicial Watch, contends that its factual allegations about the nature and substance of the audio tapes at issue clearly establishes them to be presidential records, regardless of how they were treated by President Clinton. The court is not so sure. But even if the court were inclined to agree with our reassessment of President Clinton's decision, it would not alter the conclusion that the injury cannot be redressed. And this is the kicker. The Presidential Records Act does not confer any mandatory or even discretionary authority on the archivist to classify records. Under this statute, the responsibility is left solely to the president. While the plaintiff casts this lawsuit as a challenge to a decision made by the National Archives, the Presidential Records Act makes it clear that this is not a decision the archivist can make. And in this particular case, it is not a decision the archivist did make because President Clinton's term ended in 2000 and the tapes were not provided to the archives at this time. So there you have it. A court decision that quite persuasively, we lost. We lost this, so we know what the law is. You know, we generally know what the law is because we're in litigation, but we really know what the law is when we lose a lawsuit because you never like to lose. And we lost this one. And here you have a district court judge interpreting an appellate court decision that was the guiding decision for the government's handling of presidential records and saying, no way the archives can come in and get these records. No way. There's no enforcement mechanism, and yet they went ahead and pretended there was, and they concocted and told a judge, in my view, misled a judge, that he had the authority under law to authorize a warrant to get presidential records. And don't be distracted by the fact that there were so-called classified records in the boxes that weren't presidential records. Classified records are a subset of presidential records. So if he thinks they're personal, it means they're already declassified. There was no authority for the Justice Department to ask a judge to authorize a subpoena to enforce the Presidential Records Act. And obviously, the judge had no authority to implement or approve a warrant that had no basis in law. That's what happened here. So this affidavit, by the way, is evidence of abuse of authority, abuse of power, and government corruption. And I'm glad Judicial Watch got it out. And once again, this affidavit and these documents further confirm just how dishonest the Justice Department is. I talked about how in this case, they refused to go after Clinton records. Well, are they now going to go after Clinton records? I doubt it. Of course you know. They're not going to do anything like that. And how they refused to do anything similar against Hillary Clinton. This is what they wrote in the document. One of my colleagues pointed this out to me in the Trump warrant. 184 unique documents bearing classification markings were within the 15 boxes that Trump's legal team returned to the government earlier this year. Of those, 67 documents were marked as confidential, 92 marked as secret, and 25 marked as top secret. Now, just because they're marked, as I said, doesn't mean they're classified. If they're declassified, those markings are artifacts, right? It's an historical artifact. This is a record that previously had been classified, but because it was in President Trump's possession after he left the Oval Office and he had taken them with him out of the White House, they were presumptively declassified. That's the law. And this is what Comey said about Hillary. From the group of 30,000 emails returned to the State Department by her, 110 emails and 52 email chains have been determined by the owning agency to contain classified information at the time they were sent or received. 8 of those chains contained classified information that was top secret at the time they were sent. 36 chains contained classified information, secret information at the time, and 8 contained confidential information, which is the lowest level of classification. So Hillary had 110 classified emails, chains. Trump allegedly had 184. Of course, the big difference is that Trump had a right to those records, and he had declassification authority under the Presidential Records Act. And none of this was declassified by Hillary while she was there. Certainly, she had no authority to declassify them after she left. Yet, Trump's home was raided and Hillary was treated with kid gloves. Dramatic evidence of corruption. So it's, again, your Judicial Watch taking the lead. The left is upset that Judicial Watch and I am telling the truth about the sham basis of this abusive raid on President Trump. Sham basis. There is no good faith basis. Now, allegedly, there are people around Trump who leaked my alleged conversations with President Trump. I don't know what they're up to. I don't know who CNN talked to. But I do know what the truth is. And the truth is that President Trump had a right to these records. The Justice Department's interpretation of the law, the Archives' interpretation of the law, and more importantly, the court's interpretation of the law said he had a right to these records, and they pretended he didn't and played games with the court to get this abusive raid on him. Incredible. Incredible. And this is the same FBI that's protecting Hunter Biden, protecting Joe Biden. Remember, this raid came shortly after it was disclosed by whistleblowers that the FBI had suppressed and buried an investigation of Hunter Biden's laptop just before the election. And sure enough, this week, we have more information about the FBI's subversion of our Republican form of government, where you had Mark Zuckerberg of Facebook essentially admitting that the FBI came in and said, oh, watch out, there's going to be Russian disinformation being dumped. And sure enough, the Hunter laptop comes out, and Zuckerberg says, well, this is what they must have meant. And so he suppressed it. His Facebook suppressed it just before the election. So you had the FBI obstructing its own investigations and censoring Americans and trying to pressure big media, big tech to censor Americans about the Hunter Biden laptop just before the election. And then they go and raid this poor man's home, President Trump, based on nothing, a document dispute. I was shocked by it. That's one of the reasons I get outraged, because I genuinely expect people to do the right thing. And it's surprising to me and disappointing and outrageous when they don't. I'm outraged because I'm an optimist who often has to meet reality in my work here at Judicial Watch. So that's where I get this outrage from. It's because I'm an optimist. And it's upsetting to see people that you hope would do the right thing and you would expect do the right thing, don't. And in this case, the FBI is in a moral and ethical collapse, and they can't be trusted to tie their shoes, let alone raid, do something as sensitive as concoct or manufacture a reason in working with the deep state DOJ, the Biden operation that's running the DOJ, the anti-Trump activists at the Archives, who thought that they could get the FBI involved because they wanted documents for history that they had a right to, but the law didn't allow them to get. Completely, it's kind of this hijacking of our Republican form of government and our separation of powers that protect all of our liberty by these bureaucrats and these political appointees. And of course, Judicial Watch will now consider whether or not, and this is something our lawyers are taking a look at, what are we going to do about these redactions, huh? What do you think we should do? Should we just let them sit? I don't think we're going to do that. I get to play client as corporate representative for Judicial Watch, as president of Judicial Watch. So I'm going to encourage some type of effort to try to get more access to this information. It's important to remember that our leadership forced the release of this affidavit, but there's more to be done. As I noted, it's a remarkable and historic victory for transparency that Judicial Watch today was able to get out this affidavit, which obviously is infamous in nature. And we now know why the Biden Justice Department, as I've been explaining, did not want to release this material, as it exposes how there was significant evidence that President Trump cooperated and that there was a major legal dispute about the status of the records believed to be in Trump's possession. And yet the FBI abusively raided his home anyway. And, It's one thing to have these redactions in the affidavit, and one thing you need to figure out as we're deciding what to do about it is, well, why is it they redacted it? Well, the Biden Justice Department, their dishonest redactions include redactions of the reasons for the redactions. That's your government at work. And of course, that just makes a mockery of the American people's right to know about this FBI raid, which is unprecedented and destabilized the country. So we're pushing hard, not only in this case, but as I've discussed before, we filed several Freedom of Information Act requests for the disputes behind the raid on Trump's home, including a request to the National Archives for records about their communications back in February 2022 or shortly before then that resulted in the initial transfer back to the archives or to the archives from President Trump of some of these documents. Now, of course, they didn't want to give us any of those documents. So this National Archives, which is telling us that we have to enforce the law when it comes to the handling of government documents, refuses to follow law when it comes to transparency for the American people. We asked for these documents back in February, by the way. February. We knew something was up from the get-go. All records regarding the referral from the National Archives to the Department of Justice regarding the records management procedures of former President Trump. This requests all related records of any communication between any official or employee of the archives and any official or employee of the Justice Department or any other branch, department, agency, or office of the federal government. That includes the White House there. All records regarding the retrieval of records from President Trump or any individual or entity acting on his behalf by the National Archives and Records Administration. This request includes related records of communications between any official or employee of NARA and the President Trump or any individual or entity acting on his behalf. We want the full truth. The Biden administration's raid on President Trump's home, as I keep on saying, and I'll say it once, and I'll say it until I'm unable to say it anymore. It's outrageous, reckless, and an unprecedented abuse of power. And the American people have an urgent right to know how the Biden administration manufactured the records dispute used as a pretext for the raid on Trump's home. And the Biden administration's unlawful secrecy on its political raid of Trump's home speaks volumes. So if you think everything's on the up and up, why are you hiding records from us? Why do you want to redact everything? Why are you pretending that there are essentially state secrets at issue when in fact you know there aren't? You think you should be able to raid the president's home without fully disclosing a basis for it? Of course not. The American people have a right to judge how the federal judicial system is operating and how the Justice Department that's entrusted, I don't think it should be trusted, but it is entrusted under law with enforcing the law. I don't know about you, but I don't trust this Biden administration, and I don't trust any Justice Department, frankly, under any administration these days, given the corruption that we've seen, or the FBI, to fairly administer justice. So that's why we have a new FOIA lawsuit in addition to our historic transparency legal battle in Florida for the Trump raid material. And we'll see what they're hiding. The battle for transparency has just begun. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.